Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host, and this is our weekly YouTube live stream being broadcast live Thursday, March 8th, 2018 at 9 p.m. Eastern Time. And this live stream will also be posted as an episode of the Counting to Five audio podcast. If you are watching this live stream, if you're watching live, please feel free to ask questions at any time in the YouTube live chat, and I'll try to monitor it and periodically answer any questions as they come up. These weekly live streams are held every week. We're trying to keep a regular schedule of Thursday evenings at 9 p.m. Eastern. In these weekly live streams, we try to keep up to date with all of the latest news coming out of the Supreme Court. And here's what I plan to cover today. The court granted two new cases. So they agreed to hear two new cases. These will be cases coming up next term. And we'll talk about each of those. There's some interesting legal issues in these two new cases. The court also issued two new opinions in argued cases. These were both unanimous decisions, but they're not in cases that most people have probably heard of. These are not very high-profile cases, but still kind of interesting little opinions. And then there's a few other kind of miscellaneous orders that came out in the last week. So without any further ado, I'll just dive right in and get started. Let's talk about a few of the other developments at the court. So last Friday, that's March 2nd, the court issued a stay order in a case called Henry Schein Inc. v. Archer and White Sales Inc. Now, this is a lower court case that has not yet made its way up to the Supreme Court, but this is a party in that case made an application to the court to stay the proceedings below, pending a petition to the Supreme Court. They're asking the Supreme Court to take the case, and they're arguing that they will be harmed if the proceedings below are allowed to go forward in the interim. And what this case is about, it's a case under the Federal Arbitration Act, and if you've listened to previous episodes, you may recall this is something that's come up several times before. But the Federal Arbitration Act is a federal statute that makes contractual arbitration provisions enforceable in court. So if you have a contract that says disputes arising under this contract will be subject to arbitration, then if a party sues under the contract, the other party can invoke that arbitration clause to have the case basically tossed out of court, and the suing party would be forced to go through arbitration instead. And specifically, this is about a part of an arbitration provision known as the Delegation Clause, and this is a very common feature of arbitration provisions that says if there's a dispute over whether certain issues fall within the arbitration provision in the first place, then that very question of whether these issues are arbitrable should be first decided by the arbitrator. So if one of the parties says this does not fall, what I'm suing you over doesn't fall under this arbitration provision, so I should be able to go straight to the court, the delegation clause can be invoked to say, no, go to the arbitrator and have the arbitrator decide if this belongs in arbitration or belongs in court. That's the basic idea. Now, what is this particular case about? It was a lawsuit between a dental equipment manufacturer and a distributor and servicer. The distributor, that's the Archer and White, they brought an antitrust action alleging an anti-competitive restriction on sales territories. So they brought this against the manufacturer, Schein. The manufacturer moved to compel arbitration, so invoked this arbitration provision and said, you can't sue us in court, this needs to be arbitrated. The district court denied that motion, so allowed the claim to stay in court, invoking an exception that has arisen in the lower courts, an exception to the general enforcement of these arbitration provisions under the Federal Arbitration Act. It's referred to as the wholly groundless exception. When a court says that an argument for why a particular dispute is arbitrable, so falls within an arbitration provision, when that argument is wholly groundless, then courts should retain those cases rather than allowing the delegation clause to be used to send them out to an arbitrator. And the idea is that would just be wasteful, and it would send things to arbitration that don't belong there, only for it to have the arbitrator send it back to court. And so the parties in this dispute, they frame this exception very differently. According to the manufacturer, the one who's trying to compel arbitration, so get this sent into arbitration, this whole wholly groundless doctrine that's arisen in the lower courts is an example of the lower courts kind of evading clear Supreme Court precedent on the enforceability of delegation clauses, and it kind of reflects this hostility from some judges to arbitration, to broad arbitration provisions, and the Supreme Court's upholding of arbitration provisions. On the other side, the argument on the other side is that no, that this is just the courts evaluating the contractual boundaries, and that's necessary anytime you're relying on contractual provision, including the arbitration provision and the delegation clause within the arbitration provision. It has some bounds, and the court needs to decide if that provision even applies at all, whether this dispute is even within the contract, and so that this really should just be seen as a routine application of a non-controversial idea. Is this even within the subject matter that's contemplated by the arbitration provision in the contract in the first place? So in any case, the Supreme Court granted the stay, and the lower court proceedings are on hold. The party that sought the stay argued that they would face irreparable harm if the lower court proceedings were allowed to go forward. The trial in this case is currently scheduled to start in May, and so they are arguing that they'd be forced into a trial that the whole purpose of an arbitration provision is to avoid and incurring the expenses required to prepare for trial. And so if arbitration provisions are to be effective in allowing parties to choose these less expensive and less burdensome options to litigation, then there needs to be some teeth to that, and a stay should be granted. That's the basic argument there. What's the implication of the court granting this stay order? Well, there's no telling whether the court will actually end up taking this case. The petition has not even yet been filed by the parties. They just made this emergency application for a stay to give them time, and the court may or may not take the case. But the fact that they granted the stay is a good sign that they're at least very seriously considering it, and this is an issue that that at least a number of the justices, takes 5 justices to grant a stay, so at least 5 of the justices on the court think that this is a serious enough issue that it's worth considering. So it will just have to wait and see what happens in the future on that case. One other interesting development was on Monday. So on Monday morning, the court issued its orders list, and that's a list of orders that come out of its regular private conferences. And the court had a conference last week on Friday, and these orders lists routinely include long lists of numerous petitions that the court is denying. So cases that had sought cert at the Supreme Court, so they'd asked the court to hear various cases. And if you've been following the Supreme Court, you know that the court only takes something in the ballpark of 1% of all the petitions that are sent to it are actually accepted onto the court's docket. So the vast majority of cases just get denied, and almost all of these cases get denied without any comment. It's just a single line on an orders list that lists the name of the case, and then it'll say the petition for certiorari is denied. But occasionally, a justice wants to say something more about a particular case, and there was one example of that that came out with Monday's order list, and this was a case called Wessinger v. Vinoy. And Justice Sotomayor filed an opinion dissenting from the denial, so arguing that the court should have accepted this case, should have taken this case. So what is this case about? Well, it's a capital sentencing case. So Wessinger, in this case, is a convicted murderer. He was convicted in 1995 of a double murder during a robbery of a restaurant where he had formerly worked. And the key issue in this case is ineffective assistance of counsel. The argument specifically is that his counsel was ineffective at the capital sentencing stage of his case. So in a capital case, they're generally divided into two phases. There's the guilt phase, and if a defendant is found to be guilty of a crime that carries a potential death sentence, then there's a sentencing phase where evidence will be presented to the jury, and the jury will have to find that there were some aggravating circumstances that make someone that mean that defendant ought to get the death penalty. Now, part of that sentencing phase is normally the presentation of mitigation evidence by the defense. Now, it's important to understand that under Supreme Court precedent, in capital sentencing, a defendant is entitled, can't be limited in the subjects that they present in mitigation. A defendant is allowed to present evidence of anything that a jury might find would reduce their culpability. So this can include things about the specifics of that crime, or it can be general things about the defendant and their life, and possibly things about their upbringing, or things about their mental state, things like that. Anything that might potentially cause a juror to feel that they have reduced culpability for the crime that might lead a juror to decide against the death penalty. And in this case, the argument is there were some mitigation evidence specifically related to brain disorders that this criminal defendant had that affect his executive functioning, impulse control, things like that, and also just evidence about his childhood, about growing up in poverty, and that type of information. None of that was presented at the capital sentencing. So there's an argument that there was ineffective assistance of counsel, but it's a bit more complicated than that, and that it kind of brings us into some of the complications that are involved in habeas corpus cases. So a habeas corpus case is what's known as post-conviction review. It's separate proceedings that are brought to challenge a previous conviction, and these generally go in two phases. There's state habeas review, where someone goes to a state court through whatever procedures a state court has established for this type of thing to raise claims, including claims that the counsel was ineffective at trial, and then a defendant can follow state habeas with federal habeas claims, where they go to a federal court and bring them. But the entire habeas process is quite complicated, and there's very specific rules about raising claims and waiving claims that aren't raised at the appropriate time during the whole process. And specifically, when a claim is not raised in state habeas, and then a party goes to the federal court and tries to raise that claim that they didn't bring up in state habeas, it's called procedurally defaulted. That claim is no longer can no longer be brought. You waive your right to bring that later by failing to bring it at the appropriate time in the whole series of proceedings. Now, in this particular case, the allegation here is that the state post-conviction counsel, so this is the attorneys representing the defendant in the state habeas proceedings, failed to investigate mitigation. So failed to investigate whether there was additional mitigating evidence that could have been presented by the trial counsel. And this is a quote from Justice Sotomayor's opinion. It says, counsel did not obtain any medical records, school records, employment records, or family history records, and did not conduct interviews of any witnesses, friends, teachers, coaches, or family members regarding potential mitigating factors, aside from having a couple brief conversations with Wessinger's mother and brother. So the argument here is that the state habeas counsel was basically ineffective. So you have two different layers of ineffective assistance. First, you have trial counsel who is alleged to have provided ineffective assistance by failing to present mitigation evidence at the sentencing hearing. And then you had state habeas counsel who were ineffective in not uncovering that failure by trial counsel. And this is important because the Supreme Court decided a case in 2012 called Martinez v. Ryan. And in that case, they argue the court held that when as is sometimes the case, when the first opportunity that a defendant has to argue that their trial lawyer was ineffective is in state habeas, then if the state habeas lawyer is also ineffective, that won't amount to a procedural default. So the idea is that the defendant needs at least one fair opportunity to raise the ineffective assistance of counsel, and if their habeas counsel is also ineffective, then that takes away that opportunity, and so it doesn't. They're not stripped of the ability to bring that claim in federal court. Now, the issue here is that the Fifth Circuit, which is the Fifth Circuit Court of Appeals, where this case came up from to the Supreme Court, they decided they held that there was no ineffective assistance of counsel by the state court post-conviction counsel. So the state habeas corpus counsel was not ineffective. Therefore, Wessinger is barred from raising this claim in federal court because there wasn't ineffective assistance in the state court. Justice Sotomayor disputes this very heavily, saying that there basically was no excuse for the failure to investigate mitigation by the state habeas counsel, and concludes with some fairly strong language, saying, here's another quote from Justice Sotomayor's opinion. The layers of ineffective assistance of counsel that Wessinger received constitute precisely the type of error that warrants relief under this court's precedent. Yet Wessinger will remain on death row without a jury ever considering the significant mitigation evidence that is now apparent. So that's kind of the size of that. Now, Sotomayor was the only name on this dissent. Now, that doesn't necessarily indicate in these cases. It's kind of a strange practice that the court has, but on these orders, when we're not talking about the signed opinions after an argued case, but we're just talking about various other orders that are issued by the court, dissents are not necessarily indicated. A justice can dissent, but not choose to have their dissent noted, so that it just it looks like just any other case, just a line saying denied with no other indication or no other notation on it that would indicate that any justices disagreed with that. And it's conceivably possible that other justices could agree with Justice Sotomayor. One or more other justices could also agree with her here. But the fact that she's the only one with her name on this suggests that she's all by herself on this. And as is typical in these dissents from a denial like this, there's no response from the other members of the court explaining the denial of the petition. It stands alone. It's which is, as I said, is typical. That's normal for these. You'll see these occasional dissents from a denial, but it's unusual for there to be any response from the justices that agreed with the denial. So you're left just to speculate on exactly where the disagreement is. Is it just a disagreement over Sotomayor's analysis of the specific facts of this case, or is it a concern that this case is too fact specific? This is just a pure error correction of a lower court and doesn't raise a larger legal issue that will apply to a lot of cases, which is the type of thing the court usually looks for in its cases. But we really have no idea. It's just pure speculation. So it's just an interesting data point, and just interesting to kind of get a glimpse into the thinking of at least one member of the court. But it also kind of highlights how opaque some of these things are, and how little we really do know about how what the justices are thinking when they don't spell things out for us. So with that out of the way, I'm going to move on to the new cert grants. So on Monday, also as part of the Monday orders list, the court granted cert, so that's agreed to hear 2 new cases. And these are cases that will be on next next term's calendar, so the term starting in October of 2018. And that brings us up to 6 cases so far that they've granted for next term. And again, they'll continue to fill out this calendar throughout the rest of their of this term, throughout the end of June before they break for the summer. They'll continue to add cases to their fall calendar, but they're up to 6 so far. And these 2 new cases are interesting. One is a specific issue that has it's taking aim at a case that has long been a target of certain critics of eminent domain practices, and the other case is kind of an interesting. It's a raising a constitutional doctrine that kind of doesn't get much hasn't had much attention from the court in a long time, and so let me run through each of those now. So the first case is called Nick v. Township of Scott, Pennsylvania. And this is a case about the underlying issue is the takings clause of the Fifth Amendment. And this is the portion of the Fifth Amendment that says, nor shall private property be taken for public use without just compensation. And specifically, this is a case that's challenging a 1985 Supreme Court case called Williamson County Regional Planning Commission v. Hamilton Bank. And this is a in the area of takings claims. So this is claims that the government has seized private property and owes compensation. In those types of cases, Williamson County is a very significant case. And that case said that when someone is bringing a case under the under the just compensation clause or of the takings clause, the just compensation provision, where it says private property shall not be taken without just compensation, and someone is saying that they haven't received just compensation, the court held in that case that before they can bring that just compensation claim in federal court, the plaintiff must use whatever procedures the state has available to try and get their just compensation through state procedures. But that includes not just an administrative procedure the state might have in order to provide for evaluation of property or things like that, but it includes using the state courts, including if a plaintiff needs to actually sue the state or sue the agency or the municipality or whoever is involved, sue them, bring them to court, alleging a taking and demanding payment of compensation. These actions are they're usually referred to as inverse condemnation actions, and so that's an action by a property owner against the government seeking compensation for a taking. It's kind of the backwards of a condemnation action is when the government comes in to seize a piece of property. Inverse condemnation is when the property owner sues the government saying, you have taken my property and now you owe me money. But the Williamson County case said that a property owner, before they can come into federal court and raise this constitutional claim that they have been denied just compensation, they need to use all available state proceedings, even if that means suing the state to try and get their money from the state in court. And we'll come back to that in a moment, but let's talk about the specific facts of this case. So Nick, the party in this case, her name is Rosemary Nick, and she owns 90 acres of land in rural Pennsylvania, and the land includes a single-family residence and grazing land for animals. And the property is bounded by stone walls and fences and marked with no trespassing signs. And the issue here is, in 2012, the township of Scott, so Scott, Pennsylvania, that's where this property is located, passed an ordinance. And the ordinance said that all cemeteries shall be kept open and accessible to the general public during daylight hours. Now, significantly, cemetery was defined as a place or area of ground, whether contained on private or public property, which has been set apart for or otherwise utilized as a burial place for deceased human beings. So what this is saying is any property that has any private property that has a burial site on that private property must be kept open and accessible to the general public. Moreover, the ordinance authorized code enforcement agents to enter private land to determine the existence and location of cemeteries, and allowed them to issue fines, $300 to $600 per day, fines for violating this ordinance that is not keeping these burial places open to the public. Interestingly, this ordinance was apparently specifically targeted at Nick, at Rosemary Nick. There were local residents who apparently claimed to be descended from Revolutionary War era burials on Nick's property and wanted access to that burial site, and the township passed it in response to that. It's not clear from the briefings that I've read. It's not clear whether there are other private property in this township that's been affected by this, but it looks like it was, at least in part, it was directly attempting to gain access to Ms. Nick's land. Now, what happened after this ordinance was passed was in April of 2013. So this was passed in 2012. A code enforcement officer entered her land unannounced, identified grave markers on that land, and then cited Nick for a violation of the public access requirement, and ordered her to make access to the burial site available to the public. Nick went ahead and filed an action in state court, challenging this as a taking, so arguing that this is a classic taking. Basically, it's creating an easement on her land and allowing the general public to physically occupy this piece of land. Would be a classic type of takings claim. And in response to that, the town agreed to withdraw the citation and not, at least for the time being, not to enforce the ordinance. And because of that posture, the state court refused to rule on her takings claims because they had withdrawn the citation and were not enforcing it. So she went to federal court to bring again the same takings claim, saying that this ordinance, the ordinance itself, by forcing her to open up her land, was constituted a taking, and she should be compensated for that infringement on her property rights, the normal right that comes with ownership of property to exclude the general public from access to the property. But what happened was the federal court dismissed her case under the Williamson County case, so saying she had not fully gone through the state court. The state court had not fully ruled on her claims, and so she couldn't bring this to federal court. She had to go through the state court and use all available state court processes to try and get compensation there before she could go into the federal court. This case is directly challenging Williamson County. Now, here she argues that here's what we have. We have the undisputed facts here are that the township enacted an ordinance that authorizes the public to physically occupy her land. The township actually enforced these provisions against her, issued a citation for failure to open the land up to the public, and commanded her to provide access to the public. And the township has not paid or offered compensation, and the ordinance contains no provision that provides for compensation for this. So she says, given all those facts, she's established a taking without compensation. That should be enough to get her into federal court. And this kind of brings up, there's a lot of criticisms have been made of the Williamson County the rule over the years since it's been in place, and some of these are very practical critiques. And one is that it ends up, the argument is that it ends up just putting in place worthless procedural hurdles that people have to jump through. Some of the state court processes that people have to resort to before they can get into federal court are just futile. For example, if someone has brought a challenge in state court against an ordinance, a facial challenge to the ordinance, and that's been denied, and then they go an action after that to seek compensation for an inverse condemnation proceeding is usually doomed to failure. Also, if someone has made a zoning application that's been denied and then has to go and seek a variance, there's usually a higher standard for a variance, and if they've already been denied, that's likely futile too. So they have to jump through these procedural hurdles for no good reason. There's also, and this is a concern, that there's been some pretty very questionable gamesmanship by some government agencies under this. Now, I mentioned that Williamson County says if you haven't fully gone through the state procedures, then you can't get into federal court. Well, there's a process when a claim raising a federal right, so a federal issue of federal law, is brought in state court. The defendant is often entitled to it's what's known as removal, is entitled to take that case in state court and remove it from state court and bring it into federal court. What has actually happened in a number of cases across the country is a party has brought one of these claims, for example, an inverse condemnation claim, in state court, and then the government entity that's involved in the case removes that case to federal court. So it says, well, this involves a federal claim, so let's take it out of state court and put it in federal court. And then once it gets to federal court, they argue to the federal court that under Williamson County, the federal court can't hear it and it needs to be dismissed. And in some cases, courts have gone ahead and done that, and they've dismissed these cases, even though the government entity was the one that brought it into federal court in the first place and took it out of state court. So either the plaintiff ends up running in circles, going from state court back to federal court, and then has to go back to state court, and it's just wasting time. In some cases, it's caused them to cases to be barred from court by the statute of limitations, because by the time the federal court gets dismissed, it's too late to go back and bring it back into state court. Even if the federal court just sends it back down to the state court rather than dismissing it outright, that just wastes time and money for no good reason, and it allows this crazy gamesmanship to happen. And then one other criticism is that part of the reason that plaintiffs want to get into federal court is they may feel like they'll get a fairer shake when they're going against a government entity in federal court than they might in state court. However, once these claims have been fully litigated in state court, federal law requires the federal courts to give full respect to the state court's decision, and that means any issues that are decided in the state court proceeding, the federal court is bound by that. So there's no new opportunity to actually argue the compensation issues in federal court if they've already been decided in the state court, and the federal court is just bound by whatever the state court decided. So essentially, through combinations of these different barriers, the argument is that Williamson County ends up just denying people a federal venue, a federal forum to hear these federal constitutional claims. And so those are kind of the practical criticisms. And then the I guess more doctrinal legal criticisms are that the argument is that it doesn't make sense to require people to go through all of the state legal processes available. It's conflating the government entity that's actually involved in taking the property. So here it was the township. It was this Scott Township in Pennsylvania that enacted this ordinance. The Scott Township doesn't have any procedures in place to provide compensation under that ordinance. So the argument is that should be enough. They shouldn't have to go through everything that any part of the state government provides. The fact that the court system exists and that there are claims like inverse condemnation that could potentially be brought, it doesn't mean that the taking isn't complete when the township, the one that's actually imposed the infringement on the property, when they have done something without compensation, there's no reason to conflate them with the entire state government. And there's also a strange kind of aspect to it by saying that in federal court, by saying, well, the claim is not really ready to be heard in federal court because until the state has definitively denied compensation or denied just compensation, there's no kind of complete full claim to bring in federal court. But if it's enough to bring in state court, if you can bring the action in the constitutional claim in state court and argue that that you've been denied just compensation, and that's allowed in state court, then it seems like the claim is complete. If the state court recognizes that as a complete claim, why can't it go into federal court? So those are, various criticisms that have been made of this. So it'll be interesting to see what the court does. The fact that they've agreed to take this case suggests that there may be members of the court who are willing to reconsider this doctrine or potentially cut back on it. So we'll see. Again, that'll be coming up early next term, possibly as early as the October oral argument sitting. Now, the second case that the court granted on Monday, that'll also be up next term, so starting in October, is a criminal case called Gundy v. United States. Now, this case, the issue is a very unusual issue. This involves the Federal Sex Offender Registration and Notification Act, which is known as SORNA for short, SORNA. And the specific issue here is a challenge to the Congress's delegation of the retroactive application of SORNA to the Attorney General. Now, I'll break that down and kind of get into it. First, real quickly, basic facts of this case. The criminal defendant here is named Herman Gundy. He was convicted in 2005 of a rape and sentenced to time in state court, and he had some other prior convictions, and in any case, he was later released from prison. In 2013, he was arrested and charged with for traveling interstate without registering under SORNA. So he was convicted of a sex crime. He did not register under the Sex Offender Registration and Notification Act. Then he traveled interstate, and that subjected him to prosecution under SORNA's criminal provisions. Now, he raised several issues in his case, several issues related to this prosecution. There were some strange facts of the prosecution, including that the interstate travel that made him criminally liable actually occurred while he was still in federal prison custody and was transferred from one place of custody to another. But the only issue that the Supreme Court is hearing in this case is just one discrete issue about retroactivity. And here's what it's about. So he was convicted of the sex offense involved in this case. He was convicted in 2005, but SORNA was not enacted until 2006. So the question here is, do people who are convicted before SORNA was passed need to register under SORNA's provisions? Now, SORNA itself didn't answer this question. Here's what it said, right? It said, the Attorney General shall have the authority to specify the applicability of the requirements of this subchapter to sex offenders convicted before the enactment of this chapter. So it just says the Attorney General will specify whether these requirements are applicable. It doesn't say, it doesn't say one way or the other whether they are. In 2007, the Attorney General issued a regulation saying, the requirements of SORNA apply to all sex offenders, including sex offenders convicted of the offense for which registration is required prior to the enactment of that act. So Congress said in the act, Attorney General shall have the authority to specify whether it applies. The Attorney General said, yes, it applies to everybody, including if they were convicted before the act was passed. So that answers that. And that's what's being challenged here is specifically the delegation of this decision to the Attorney General. Now, just as a side note, you may be asking, how can this be retroactive? You may think, isn't there a provision in the Constitution that the bar on ex post facto laws that says the government can't impose retroactive punishment? Now, this was addressed in a Supreme Court case from 2003 called Smith v. Doe. Now, that was about a Alaska sex offender registry. This is before SORNA was enacted, and the Supreme Court said that these could be retroactive. At least in the Alaska case, they said this could be retroactive because what this registry was, it was just a civil registry, just a government listing of names, addresses, other information, and it in itself was non-punitive. It was intended for public notice and information purposes, for tracking, things like that, not for punitive punishment purposes. Therefore, it was not. Wasn't itself imposing an additional punishment. So that could be imposed retroactively. Now, criminal violations of the sex offender laws, those can only occur prospectively, so after the law is passed. But the actual registry itself, the requirement that someone register, can apply if the crime that someone's being required to register for happened beforehand. Now, the Supreme Court hasn't specifically ruled on that issue under the federal SORNA. As I mentioned, that Smith v. Doe case was about the Alaska registry. but several lower federal courts have, and the general consensus is that the court would probably come out the same way on that. So that's not specifically an issue in this case. The issue in this case is under something known as the non-delegation doctrine. Now, this is a constitutional theory. The basic idea is that the U.S. Constitution grants legislative power, so that the power to make the laws is granted to Congress. And that comes out in the very first sentence after the preamble of the Constitution. The very first sentence of Article 1 starts like this: all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. And the idea is, the Constitution says legislative power is in the Congress, and the Constitution goes on to establish very specific requirements for the exercise of legislative power. You have what's known as bicameralism and presentment, meaning that majorities of both houses of Congress have to pass legislation, plus it needs to be presented to the president for the president's approval or potential veto before any legislation can be enacted. So the Constitution says that Congress has legislative power, and Congress exercises legislative power in a specific, defined way. And the argument is that this constitutional structure is important. It creates certain institutional checks on the exercise of power. It also creates political accountability, because the legislators have to actually vote on new laws going into effect. And the argument is, under this non-delegation doctrine, the argument is if Congress is going to delegate legislative power to other government officials, it circumvents this constitutional structure, right? So the problem here is modern governance is structured around a very large and very active administrative state. There are huge amounts of modern law that is channeled through administrative agencies, and agencies create an enormous amount of binding law by enacting regulations that are binding both on various businesses and corporations engaged in various activities, and also regulations that are directly binding on individual Americans. So this this looks on the surface looks like the exercise of legislative power delegated by Congress to these administrative agencies or executive branch officials who are exercising that legislative power on Congress's behalf under these delegations. So to understand this, I'm going to have to jump back and do kind of a very brief kind of recap of the history here, just very briefly. So the non-delegation doctrine, it reached its high point in 1935. Now, in 1935, the Supreme Court decided two cases, holding in each of those cases that delegations of authority from Congress to executive branch officials were unconstitutional as unconstitutional delegations. One of those cases was called Panama Refining Co. v. Ryan, and the other was called ALA Schechter Poultry Corp. v. United States. And those cases were not close cases. The Panama Refining case was 8-1, and Schechter Poultry case was a 9-0 decision. And in those cases, the court referred to something that's known as the intelligible principle test. So the basic idea is that Congress, in order to delegate to an agency or executive official, Congress has to establish an intelligible principle that guides the agency in its exercise of this delegated authority. So in rulemaking power or other legislative authority, there has to be some intelligible principle. They can't just have unguided discretion to do whatever they want to do. And the court, when it struck down these two delegations in these cases, it said that basically Congress had given just unbridled legislative authority to the executive branch, and that was going too far. Now, the context at the time is this is 1935, so this is during the Great Depression, and these non-delegation decisions were viewed as a direct challenge to some of Franklin Roosevelt's New Deal programs. And this was part of a broader conflict between Roosevelt and a majority of the Supreme Court. And the history of this is complicated, but partially due to a change in the court's membership as some justices retired, and Roosevelt eventually was able to appoint a large majority of the court's membership. The court soon stopped opposing Roosevelt's New Deal policies and didn't strike down any more delegations of authority. And here's the important thing. Since 1935, the Supreme Court hasn't struck down a single delegation to an agency or executive official as a violation of the non-delegation doctrine. So they struck down 2 of these delegations in 1935 and have not done so since. However, the intelligible principle test is still officially, that's the governing law. The issue is that the court always finds a sufficient intelligible principle. So there have been non-delegation challenges brought, but every time the court says that there's enough of an intelligible principle, even in cases dealing with extremely broad delegations to agencies. For example, there have been several cases where an agency is required to make certain rules acting in the public interest, and the court has found that in the public interest was a sufficient intelligible principle to survive the non-delegation doctrine. And this has led many people to say that non-delegation is basically a dead doctrine at the Supreme Court. If in the public interest is enough to survive the intelligible principle test, then it doesn't really mean much. But this issue, there is a very active and real divide among legal academics, judges, others, that breaks down along ideological lines. And there are many members of the what you could broadly call the conservative legal movement who are broadly hostile to the vast growth of the administrative state, and have argued in academic articles, and also among judges in some court opinions, have argued that the non-delegation doctrine should be reinvigorated. It should be given some strength to rein in some of these extremely broad delegations of authority to agencies. And this has been far from universal. Justice Scalia actually wrote a opinion upholding a very broad delegation, and some along those lines have even conservative legal thinkers have argued that courts are not really equipped to engage in the kind of line drawing that a robust non-delegation doctrine would require. How much delegation is too much is not really a question courts are equipped to answer. But others have been much more skeptical. Justice Thomas has written a few opinions very skeptical about the intelligible principle test. And most directly relevant to this case, Justice Gorsuch, when he was still on the 10th Circuit Court of Appeals in a very similar case directly about the SORNA, the Sex Offender Registration and Notification Act, he wrote an opinion that raised these non-delegation issues, and I'll come back to that in just a minute. So that brings us to this case, this Gundy case, raising this non-delegation claim. The government argues, here's a quote from the government's brief, quote, "As the court has repeatedly observed, it has found only 2 statutes that lack the necessary intelligible principle, and it has not found any in the last 80 years. And the government goes on to point out that this exact question has been considered by basically all of the circuit courts, and none of them have found majorities of none of those courts have found a violation of the delegation principle." And the government just essentially reading that, you get the sense that the government is arguing, look, this is a dead doctrine. It hasn't been used really in 80 years. There's no need to take this case. So why did the court take this case? There's a couple of interesting aspects of this case that might explain that. One is the argument that's made, and this is an argument that Justice Gorsuch made in the 10th Circuit case that he decided on this issue. The argument is that this delegation in SORNA, it really is an example of no intelligible principle whatsoever. The argument is that the delegation contains no limitations whatsoever on the Attorney General's applying this law retroactively. The Attorney General could apply this to no sex offenders at all. The Attorney General doesn't even need to act under this, wasn't required to make any determination, or could apply it to every sex offender committed before the act was passed, as the Attorney General, in fact, did do. There was no in that delegation, there was nothing guiding the Attorney General or instructing the Attorney General on what to base that decision on. The only principles or details or guidance that anyone can point to is in other parts of SORNA, not directly dealing with the retroactivity issue. So maybe this is a kind of an extreme case of a lack of intelligible principle on the particular delegation. Another issue is maybe there's really a special concern over criminal statutes. So most delegation issues are dealing with just broader regulatory matters in just any of the various agencies that the administrative agencies routinely deal with. But this is a criminal statute. And depriving someone of their liberty, throwing someone into prison, is among some of the most serious things that the government can do. And courts often say that Congress should be given less leeway when it's acting in the criminal arena. And Justice Gorsuch made both of these points in his opinion when he was back on the 10th Circuit. This is a line from that opinion. He said, "Congress may effectively pass off to the prosecutor the job of defining the very crime he is responsible for enforcing." So there may be concern over this specific criminal context here. So a few things to watch for in this case. It'll be interesting to see whether this case breaks down along the stereotypical left-right liberal conservative lines. It may, because there is that kind of political or ideological valence to these non-delegation the non-delegation issue broadly. But it's also possible, because of the specific details of this case and the context, the criminal context, that maybe things would go differently. It'll be interesting, those justices who are interested in seeing this as a violation, do they seek to kind of better define the boundaries of the intelligible principle test, or are they going to seek to replace the intelligible principle test altogether, perhaps with something with more strength? So it'll be interesting to see how that case plays out. But it's interesting that the court has chosen to take up this issue that has kind of not been an active, effective doctrine in a long time. The last thing I want to touch on briefly is two new opinions and argued cases that came out also on Monday. The court issued two more cases. That brings us up to 13 total cases for the term. We're expecting 51 additional opinions between now and the end of June. So still a lot left to come in this term. But these two, both of these were unanimous cases, and neither of them are particularly high-profile cases, but I'll just touch on each of them briefly. The first one is a case called Texas v. New Mexico, and this was a unanimous opinion by Justice Gorsuch. This was also a very quick turnaround. This case was argued only back in January 8th, so less than 2 months, which is quick by the court's typical standards, given that there are still a bunch of October cases outstanding that the court hasn't issued yet. And this is a case in the court's original jurisdiction. That's a case that's brought directly in the Supreme Court rather than appealed from a lower court, because this is a lawsuit directly between two states, so Texas suing New Mexico. The basic facts of this case is a dispute over the water of the Rio Grande River, and under a compact. This is a 1938 compact agreement between Colorado, New Mexico, and Texas over access, over use of the water from the Rio Grande, so how much water each of those states is entitled to use. And the issue that the court was deciding in this particular case was whether in this dispute, so the basic dispute here is Texas is accusing New Mexico of using too much water out of the river, basically under the specific terms of the compact between the states. New Mexico is required to provide a certain amount of water to a reservoir in New Mexico that's controlled by the federal government under what's called the Rio Grande Project. And then the federal government manages water under certain agreements and kind of allocates that water between other parts of New Mexico downstream of the reservoir and Texas further on. And the argument is that New Mexico is using too much water downstream of that reservoir, so they're using too much water. So Texas is not getting its allocation. The issue here is the United States sought to intervene in this case. So they came into this case at the Supreme Court and said that they wanted to also be a party in the case, basically making the same allegations as Texas, so making the same allegations against New Mexico and citing in part the United States' treaty obligations with Mexico, because the Rio Grande makes up a large part of the border between Texas and Mexico, and the government has a treaty with Mexico where they are obligated to provide a certain amount of water to Mexico. And so they want to come in too, but New Mexico opposed that, arguing that the United States was not a party to the compact that's being sued under, so they had no standing to join the lawsuit. The case, the court ultimately decides that the United States can have a role in this case. They can intervene and remain in the case, but it's an extremely very specific case that just depends very heavily on the very specific facts of this case. The court relies on the fact that this is in the court's original jurisdiction. So these are cases where they don't come up through the lower courts; they come directly in the Supreme Court, and the Supreme Court has a lot of leeway to really shape the process and how the case is going to be heard and how it does it. This is kind of more than their usual role in typical cases. And they cite, the court cites a number of considerations that favor allowing intervention this time. They say that the compact is intertwined with these downstream contracts. That's the term the court uses for the agreements between the United States and New Mexico and Texas about allocating the water from the dam. And because those agreements are so intertwined with the compact, and the compact works only because it kind of assumed the U.S.'s role in providing water to Texas under the these downstream agreements. And also that New Mexico had conceded that the United States plays an integral role in the operation of the compact, that breaching the compact might affect the United States' treaty obligations. And also the court notes that because the U.S. here is really just piggybacking on the Texas action, they're seeking the same relief, and Texas doesn't object to it, and they're not looking for anything broader than what Texas is already asking for. So under those circumstances, the court says, yes, the United States can intervene and they can stay in the case. It's kind of odd because it's just such a narrow, fact-specific decision. It applies only in these original actions. So that means this doesn't really have broader implications to cases that will be heard in other courts. But it leaves open a lot of questions about it. It's not clear what would happen if United States and Texas's interests diverge. It doesn't really give any guidance on whether any of these four factors ceased to exist or didn't, or weren't as strong, how that would change its calculus in this particular case. So it's really a case that provides very little guidance. Now, because this is in the case's original jurisdiction, there's no need here, as in most of its cases, there's no need to provide guidance to any lower courts, because these cases will never be brought in lower courts. These type of water disputes come directly to the Supreme Court. But on the other hand, in these cases, and I've talked about this on previous podcast episodes, but in these cases, the court does not like to deal with kind of trial type processes. So when the court has these original jurisdiction cases, its normal process is to appoint a special master who basically acts like a lower court judge in these cases and conducts proceedings in these cases, which then are kind of more or less appealed from that special master to the Supreme Court. And this case really gives very little guidance to future special masters dealing with these water cases on when the United States can intervene or not. So it's kind of an interesting case. It kind of gives the impression that the court just wanted to decide this quick, get this out of its way, but without really setting down any bigger principles that may come back to have results that the court doesn't like in a future case. So that's that case. So one more opinion that came down on Monday, and this is a case called U.S. Bank v. Village at Lake Ridge. And this is another unanimous decision, but this is a very narrow opinion. This is a bankruptcy case, and it deals with a very specific provision of bankruptcy law. But it's not really about the provision of bankruptcy law. It's really about the standard of review that an appellate court should use to evaluate this particular legal standard. So it's a very, very specific particular thing that it's dealing with. However, it's a case that will likely have broader implications on a lot of issues of appellate appellate court review of cases going far beyond the bankruptcy area. So this might be a case that actually ends up having broader implications, just not really important in the bankruptcy area that it's talking about. So let me quickly run through, just try and lay out the basic facts of this case and explain what the issue that's being decided is here. The entity that's in bankruptcy is known as Village at Lake Ridge LLC. Now, which is just referred to as Lake Ridge throughout the opinion. Now, Lake Ridge is wholly owned by another company called MBP Equity Partners. Now, Lake Ridge had debt; it owed money to MBP Equity Partners, so that's the entity that owns it, and it also owed money to U.S. Bank, a significant amount. It owed $2.76 million to MBP. It owed $10 million to U.S. Bank. Now, Lake Ridge filed for Chapter 11 bankruptcy. Chapter 11 is the portion of the bankruptcy code that allows for a business to be reorganized. So this is different from Chapter 7 bankruptcies, which is where a business is fully liquidated and all the assets are distributed to the creditors. In a Chapter 11, there's a reorganization of a business, and it allows an entity to survive. The court has broad power to restructure a business, restructure its debts, its contracts, just various aspects of the business to allow it to survive and create, for example, payment plans to its creditors going forward. And it's just that the purpose of this provision is it recognizes that sometimes a business is worth much more alive than broken up and sold off in pieces. The creditors may be better off in the long run if they can keep a business alive, and even if in the short run they're getting less out of it than they would have if they just liquidated and sold it. In the long run, they may end up being better off. And a key piece of the Chapter 11 process is the Plan of Reorganization. And so this is a plan that's put together that explains how the business is going to be reorganized and how the various creditors are going to be paid, what their rights will be, and how they'll be paid going forward. The preferred way that these reorganization plans work is a consensual method where all creditors or classes of creditors, if creditors are kind of divided in different categories, all the creditors or classes agree to the reorganization, and then the plan can just be, the court can put that plan in place and it can go forward. But there's a different process, and that's what's involved here, which is known as a cram down. And that's where at least one creditor or creditor class objects to the reorganization plan. Now, sometimes that'll be the end of it, but sometimes the debtor can work around this. If there's at least one other creditor class that agrees to the plan, then and certain other requirements are met, the court can still impose this, and it's called a cram down, and it's forced on the objecting creditor anyway. There's also a requirement that the court has to see that the objecting creditors must still be treated fairly and equitably. So they have to be treated fairly, even though they're objecting to it. They have to get fair treatment out of the new reorganization plan. But here's the key issue, and this is where it comes up in this case. I mentioned that in order to have one of these cram downs, one of the requirements is that at least one creditor needs to agree to their reorganization plan. That agreeing creditor must be a non-insider. And an insider is defined in the bankruptcy code, and it's defined to include various things, including a director, an officer, a person in control of the bankrupt entity. And the issue here is you had two creditors. You had U.S. Bank and you had MBP. MBP owns Lake Ridge. And as an owner of Lake Ridge, the bankrupt entity, it is obviously an insider. So therefore, if U.S. Bank objects to the reorganization, MBP can't be the agreeing creditor because they're an insider, so they don't count. So here's what happened. So one of the board members of MBP, named Kathleen Bartlett, arranged for the sale of MBP's $2.76 million claim against Lake Ridge, arranged to sell that claim to a third party, to Robert Rabkin, who's described as a retired surgeon. And this $2.76 million claim was sold to him for $5,000. So the issue here is Rabkin now owns this $2.76 million claim. If he is a non-insider, then he can consent to the cram down plan. And that could potentially allow this reorganization to go forward. Now, Rabkin doesn't fit into any of the listed categories of insiders. He's not a director, not an officer, not any of those, the listed, what are called statutory insider categories. But the courts have held that because it refers to insiders as including these various things, it's a non-exclusive list. There can be other types of insiders who aren't those specific categories that are listed, and these are called non-statutory insiders. So the dispute here was whether Rabkin is a non-statutory insider. So despite not being in one of those specific categories, he's still an insider. And U.S. Bank says, yes, he says he's an insider. And what they cite is basically that Bartlett, that again is the board member of MBP, who arranged this deal to sell the debt to Rabkin. Bartlett and Rabkin were romantically involved. And so the allegation here is that this was not what's referred to as an arm's length transaction. Now, arm's length transaction is just a term for when two parties are transacting in their individual self-interests without a conflict of interest between the parties. So it's not a kind of a conflicted transaction. And the U.S. Bank says this was not arm's length. These people had a romantic relationship, and so this was just a kind of an insider deal in that respect. The bankruptcy court disagreed. The bankruptcy court said that Rabkin and Bartlett, despite this relationship, they maintained separate homes, separate finances. Rabkin had said that he'd done this as a speculative investment, and he did adequate due diligence before he entered into the deal. The court described this as an arm's length transaction. Now, this went up to the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals had established a test for determining whether someone was a non-statutory insider. And their test had two factors. The first was looking at the closeness of the relationship between the debtor and this potential insider, and determining whether it's comparable to that of one of the statutory insiders listed in the bankruptcy code. So that's the first factor. And the second factor is whether the relevant transaction was negotiated at arm's length. And in order to find that someone was a non-statutory insider, the Ninth Circuit's test said they had to the relationship had to resemble one of the listed relationships, and that it had to be a non-arm's length transaction. So both of those had to be met. And the Ninth Circuit said, well, the bankruptcy court found it was an arm's length transaction, so that's enough to fail the second prong of this test. The court didn't have to decide the first part, whether the closeness of the relationship was similar, because it found that it was an arm's length transaction. That's enough to bring it out of the insider test, and so that's what the bankruptcy court found. Now, here's the real issue. So we've gone through all that. This is the real issue, the very, very narrow issue that the court agreed to review. The Ninth Circuit said that the bankruptcy court found this arm's length transaction, right? And the Ninth Circuit said it was reviewing that under clear error review. That means it's going to accept the bankruptcy court's determination unless it is clearly in error that this was an arm's length transaction. That's the Supreme Court granted this just to decide the single question: was that the right standard to review this under? Right. So let me step back a little and just talk about standards of review for a second. So appellate courts review issues that have already been decided by some lower court. And the question is, when an appellate court reviews a decision that's been made by a lower court, should that appellate court give deference to the lower court's decision? So just give a lot of weight to what the lower court did and only reverse if the lower court clearly got something wrong? Or should the appellate court just decide the issue from scratch, just start over, decide the issue on its own, and just whenever it comes to a different conclusion than the lower court, reverse the lower court's decision? The answer is maybe. Sometimes it's complicated. So the most fundamental distinction when you're talking about standards of review is between what's referred to as questions of law and questions of fact. So courts regularly make factual determinations. These are sometimes called findings. The court finds facts, but courts also decide what the governing law is. They interpret the law, decide what the law is. That's sometimes called holdings. But in any case, sometimes courts are deciding facts, sometimes they're deciding the law. And the standard of review kind of reflects a division of labor between trial courts and appellate courts. So trial court factual determinations, when trial court finds a particular fact That's usually reviewed under a very deferential clear error standard. The trial court findings will stand unless they're clearly erroneous. The idea here is the trial judge is more deeply enmeshed in the factual record. The trial judge may see and hear from witnesses firsthand if there's in-court testimony. The trial court has day in, day out experience weighing facts. That's what trial judges are expert at, and that's what they do. The appellate court is working from a more limited, what's called a cold record. That they get the record on appeal, which doesn't necessarily contain everything. They're not seeing live witnesses. And here, this would include the basic facts about Rabkin and Bartlett. For example, the court's findings that they weren't living together and had separate finances. Those are issues of fact that that would be entitled to deference, and an appellate court is not going to overturn those unless they're clearly wrong. And those basic facts are not challenged here. Now, when trial courts make legal determinations, when they decide what the law is, these are usually viewed under what's referred to as a de novo standard. That's just that fancy way of saying that the court starts from scratch. It just reviews them fresh, starts over. The appellate court comes to its own determination. It doesn't defer to what the trial court says. Now, a pure legal determination doesn't depend on the specific facts of the case, and this is where appellate judges are supposed to be expert. They're supposed to be expert in legal interpretation. They're not selected for the skills at trial management, but they're supposed to be experts in determining and interpreting the law. So that would in this particular case, the Ninth Circuit's two-part test for finding a non-statutory insider, that's a legal standard, and there the Ninth Circuit didn't defer to the bankruptcy court. It just declared that that's the standard that it used, and that's not challenged here either. All right. So that's the simple issues: a pure question of fact, a pure question of law. And here, when I'm talking about how these are reviewed, the standards are reviewed for these things. I'm talking about general practice in federal court. There's many exceptions to this. Sometimes state courts are a little different. Sometimes state appellate courts don't give the same amount of deference to trial courts as federal courts do. Sometimes specific statutes will define the standard of review, a different standard of review for a particular situation. For example, you see this in federal habeas corpus proceedings. Federal courts are required to treat certain state court constitutional determinations highly deferentially. So even though they're determinations of law, the court gives a high degree of deference. Sometimes you see when a court is reviewing determinations by an administrative agency, sometimes those kind of administrative agency fact findings are given a high degree of deference. Sometimes the court decides things fresh. It depends on the situation. So we're talking in generalities here, but in general, you have this division between questions of fact and questions of law. But some things don't neatly fit in either of those categories. They have the creative name of mixed questions of law and fact. Now, these are when there's an application of a legal standard to a specific set of historical facts. You're not talking about what's the legal standard. You're not talking about what the facts are. You're talking about how does this standard apply to this set of facts. It's not always simple or straightforward. It may involve fairly vague or general legal standards. It doesn't quite fit neatly in the pure law or the pure fact category. So Justice Kagan, who wrote the majority opinion in this case, she describes the key inquiry in this case like this. She says, what is the nature of the mixed question here, and which kind of court, bankruptcy or appellate, is better suited to resolve it? And then she goes on to say, to kind of describe different types of mixed questions. She says, some require courts to expound on the law, particularly by amplifying or elaborating on a broad legal standard. These, she says, are more similar to questions of law, and these are in the expertise of the appellate court. They should be reviewed de novo, that is, start from scratch. The appellate court doesn't defer. And then she says, other mixed questions immerse courts in case-specific factual issues, compelling them to marshal and weigh evidence, to make credibility judgments, etc. And these are the things that she says the trial court is more expert at, and these should get the deferential clear error review. So she goes on, and given this, she boils down the question being reviewed in this case to a very just one simple question. She says, what are they really? What's the real question here under this arm's length transaction standard? And she describes it like this: given all the basic facts found, was Rabkin's purchase of MBP's claim conducted as if the two were strangers to each other? And then she goes on to say, that is about as factual sounding as any mixed question gets. So based on that, she says this question is a mixed question of law and fact, but it's very fact intensive. It's a very factual inquiry. This is the type of thing that the bankruptcy court should get deference on. So the result here, they say the Ninth Circuit was correct to defer to the bankruptcy court's fact finding on the arm's length transaction. So the Ninth Circuit used the correct standard of review. Now, that's the answer to that kind of narrow legal question. There's two concurrences in this case, and in this the concurrences are very interesting because they really highlight how limited this case is. So the first, there's one concurrence by Justice Sotomayor that's joined by Justices Kennedy, Thomas, and Gorsuch, and here she makes a special emphasis of the fact that the Ninth Circuit's two-part test, that required them to find a non-statutory insider, they had to say first whether the relationship is similar to the statutory categories, and second, whether there was an arm's length transaction. She notes this is not being reviewed by the court. The court is not endorsing the Ninth Circuit's test and is not considering whether that test is right or wrong. But she goes on to really cast some serious doubt on the Ninth Circuit tests. She says basically this doesn't seem to be consistent with the normal meaning of an insider. Usually when you have an insider transaction is suspect regardless of whether the particular transaction is arm's length. And when you're dealing with those statutory categories like directors and officers and things, it doesn't matter whether there's an arm's length transaction. They're insiders just because of the relationship. And so she kind of suggests that really the focus on the similarity of the relationship to the statutory categories is really what should be the primary focus here. And then she goes on from there to suggest that under a different test, if the Ninth Circuit had applied a different test that was focused more on the relationship, Rabkin might very well be an insider. He had a romantic relationship with a director of the company. He had knowledge of the bankruptcy proceedings that were happening. He got an exclusive offer to do this deal. And she says even under this clear error standard, the case might have turned out differently if the Ninth Circuit had been applying a different standard than the one that it actually applied. And she also says the court held in this case, Justice Kagan held that that the Ninth Circuit was correct to apply the deferential clear error standard, but Justice Sotomayor in this concurrence, and again this is a concurrence for 4 justices, she says that had the Ninth Circuit applied a different standard, then maybe clear error might not have even been the right standard of review to apply. So it's kind of just highlighting, the narrowness here. And there's a second concurrence by Justice Kennedy. Now, Justice Kennedy was one of the justices who also joined Justice Sotomayor's concurrence, and he says in his concurrence that really he thinks that the arm's length transaction, what was described as this, and he agreed because he joined the majority too, was this very factual type of mixed question. He thought that the lower courts should really consider fleshing out a legal standard for what amounts to an arm's length transaction. And if lower courts were to try and flesh out this standard, that would be a de novo. That would be a legal determination, a legal elaboration that the appellate courts could do without needing to defer to lower courts on that. And he thinks this could use some further elaboration. But he also goes on to say that there's some reason to think that the lower courts got it wrong, even on the arm's length transaction test that was applied here. He points to the fact that the offer that was given to Rabkin wasn't offered to other bidders. It was kind of a deal just solely to him, and that alone might be enough to put it out of the arm's length transaction category. This could even be enough to be clear error. So even under the clear error standard that the court says should be applied to this, this could amount to clear error. But he goes on to note that the court didn't agree to decide that issue. The court was solely deciding the issue of the standard of review, so that's not before it. So it's interesting because those concurrences really highlight how extremely narrow the court's decision was. The court was only deciding the standard of review of a very specific bankruptcy rule, and that specific bankruptcy rule might not even be the right rule that should apply in future cases. This case will probably be more influential for its very clear description of the process for determining the standard of review for mixed questions of law and fact. Justice Kagan is a very clear writer, and her kind of stepping through different types of mixed questions of law and fact is very readable, and that's kind of very broadly applicable even beyond the area of bankruptcy law. So it seems likely that this case will be more significant just for that general question of how should a court go about deciding what's the right standard of review to apply. So that brings me to the end of that opinion, and that's basically it for tonight's episode. That brings us to the end of this live stream episode. The next live stream will be a week from today, so that's Thursday, March 15th, again at 9 p.m. Eastern Time. That's our normal live stream time. You can always check the Counting to 5 YouTube channel to find the next scheduled live stream. What's on tap for next week? There's no conference this week. The court has no conference this week, so we're not expecting any significant orders or opinions or new cases to be granted next week, though there's always the possibility of emergency orders, things like that. The March oral argument session begins on Monday the 19th. And the court is hearing 4 cases in the first week of its March arguments and 5 cases the second week. So in next week's live stream, we plan to preview the 4 cases that are going to be argued in the first week. One of those cases has been getting a lot of attention. It's called NIFLA v. Becerra, and that's the First Amendment case about a California law mandating disclosures at so-called crisis pregnancy centers. Those are centers operated by pro-life groups that counsel women about alternatives to abortion. And that's been kind of a high-profile case. There's also next Thursday, right now there are 2 executions scheduled for next Thursday in 2 different states. So there will very, very likely be some last-minute stay applications, again, related to those death penalty cases. So we'll be keeping an eye on that also. So that's what's likely on deck for next week's live stream. Now, whether you're watching on YouTube or listening to the audio podcast, I'd love your feedback. You can leave comments on the show notes at countingto5.com or the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send me an email at mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or the audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.